guys, welcome back to True Crime with Shannon, where I cover missing persons, unsolved cases, crime news, and more. Well, I'm going to go over a bit of the gag order hearing that took place on Friday morning between the state defense and Shanon Gray, who is the attorney for the Goncalves family. Basically, the bottom line is he obviously is fighting for them to be able to speak at will about the case. Emotions were very high in the courtroom as I listened to it. And, Mr. Gray is arguing basically that the family should be able to speak more freely to the media as much as they want because they are not victims as per se or witnesses in the case. And he went on to say that the state has not interviewed the family yet, and the state kicked back on that, and they said, well, you've advised them not to. So there definitely seems to be some, I don't know if it's miscommunication or just what's going on there, but it was interesting to hear the arguments, and the actual hearing was about 50 minutes long, so I'm just going to play some bits and pieces of that.
We are now on the record. This is State versus Brian KOHBERGER, CR 29222805. We're here for a hearing on the Goncalves family's motion to appeal, amend, and or clarify amended dissemination order that was filed back on February 3rd, was delayed because the media sought some relief from the Idaho Supreme Court. There was a delay to find out what the Supreme Court was going to determine, which they did. And this morning we have the state represented by Mr. Thompson and Mr. Rudley. Mr. KOHBERGER is in the courtroom, represented by Ms. Taylor and Mr. Logston. And I believe Mr. Gray is, there he is.
Let me sit back here, Your Honor.
And I believe some of the family is participating, observing on Zoom. So before we get into the arguments, I want to address the Goncalves family and all the families, really. Didn't really have an opportunity to do this at the arraignment. My heart does go out to the families. And the loss to your children is devastating and horrific. I mean, there's no dispute about that. I also want to acknowledge and apologize because at the arraignment, I did stumble over a couple of the names, Kaylee's name and Zing's name. And I want to explain that. I was up all night, really ill, probably food poisoning, and I was not at full potential. Probably also some emotion and nerves as I read those names. And I'm sorry. So that's my apology for that. I know some people were concerned about that and I wanted to address it. I also wanted to explain a procedure at the arraignment that apparently drawn from the media that some people were confused when Mr. KOHBERGER declined to enter a plea. And I just wanted to clear that up because I didn't really see any explanation about that in the media. That is Mr. KOHBERGER's right. And under Rule 11A1 of the Idaho Criminal Rules, and this is a quote, if a defendant refuses to plead, the court must direct the entry of a plea of not guilty. That is not unusual. But reading the media, it seemed like somewhat mysterious. So I wanted to explain that, particularly to the media. It's a small issue, but it's somewhat, well, I think that I have an obligation, just as the media has an obligation, to help to educate the public about the processes that we are responsible to follow in the courtroom, and that's important for journalists. That's also important for the citizens. So, if you're curious about that, you can always find the criminal rules on the Idaho Supreme Court website. And it's very, very easy to read them and maybe get a better understanding. All right, so that's my speech for today. Mr. Gray, come on up. And
If you allow me just a minute or two to get started out here.
Take your time.
Thank you.
Thank you, Mr. Gray.
I'm going to applaud the judge. He wanted to explain himself, even though he really doesn't have to, about his mispronunciation of the victims' names. And I feel like that's a respectful thing that he's done, explaining that he was very ill the night before, and that was the reason that he was having a little more difficulty. And then, of course, that he addressed Bushy's lack of a not guilty or guilty plea.
Can I proceed, Your Honor?
Yes. Thank you, Mr. Gray.
First, Your Honor, we'd like to thank you for apologizing to the victim's family. I think it was an emotional day for them, and they appreciate your apology. I know that they took that heartfelt. Thank you. I first want to start with the procedural history of this non-dissemination order, if I could. On January 3rd, 2023, the Judge Marshall submitted a non-dissemination order. And in that order, it applied to parties in the action, which would have been the prosecution, the defense, and any agents, investigators involved in it. After that non-dissemination order was issued, I reached out to the prosecutor's office to see if I could get Judge Marshall's email. For some reason, I don't know if they took it down, but I couldn't find it online. And they informed me that they were not privy to give me that information. Then, on January 13th, there was a Zoom call that was requested by Judge Marshall. That Zoom call was requested at 1 o'clock on the 13th. I received an email at 12:58 from Judge Marshall's clerk requesting a Zoom call to speak to all interested parties. The Zoom call occurred at 4 o'clock p.m. During that meeting, the judge reminded us, all the parties involved, it was the prosecution, it was the defense, it was myself, it was the attorneys for the victims' families, the attorneys for the witnesses, I believe were there as well, a number of attorneys, and reminded us that her non-dissemination order mirrored that of Idaho Rules of Professional Conduct 3.6. As part of that hearing, and I think it's details here, she talks about the rule applies to all lawyers participating in the Zoom meeting, the state and the defense, and all attorneys for the witnesses. When she had that Zoom meeting, and I've requested the transcript from that Zoom meeting and haven't been able to receive it yet from Judge Marshall's court, so we could have a full transcript of what went on that day. But as part of that meeting, I had questioned Judge Marshall regarding the victim's family and whether or not they were allowed to speak to the media based on the fact that she had said all interested parties as well, in the initial non-dissemination order. I didn't receive any clarification. I was just instructed to go back to Idaho Rules of Professional Conduct 3.6, as well as I was told, and this is in quotes from her Zoom release, take their duties in utmost regard in conducting themselves and advising their clients. I took that as I should tell my clients to be quiet. She reiterated that again in the Zoom call by saying that I had ethical duties striked above in the Idaho Rules of Professional Conduct for commentary of Rule 3.6. And she reminded me later that lawyers have a responsibility in giving advice to their clients. I disagreed with Judge Marshall on almost every point during that meeting. As well as, if I had known that we were going to be discussing the Idaho Rules of Professional Conduct in that issue, I would have prepared. But only having a 3-hour notice didn't allow me, and not knowing what the subject of the meeting was going to be, didn't allow me to address those issues at that time. Now, after the non-dissemination order in January 3rd and then the January 13th, 2023 meeting, the judge amended the non-dissemination order on January 18th. And she basically repeated the same order, except for she added the attorneys for any interested party in this case, including attorneys representing witnesses, victims, or victims' families, as well as parties to the above entitled action. So you can see the difference is that the first one dealt with parties to the case. The second one went way over the top, addressing all attorneys that might be associated with the case, or any attorneys that might have an interested party in this case. So that's where we are today. I filed the motion based on that additional language. Now, I'd like to get into some of the issues here. It's very clear that I am not a party to the case and the victims' families are not a party to the case. That's very clear through all of the case law, as well as...
Can I interrupt you?
Yes.
There's no dispute about that.
Okay. Then
your clients are not parties. The only parties of this case are the state and Mr. KOHBERGER. That's clear. That's clear in the case law with regard to any victims or victims' families. There are constitutional protections and statutory protections for victims and their families.
I would agree.
That's well established.
So now, I do agree that the court has the power to control those that are parties to the case and that are involved in the case in some way. But we have to define that. What means involvement in the case? Part of that is that the judge referred to the Idaho Rules of Professional Conduct 3.6, trial publicity. She references that multiple times as the basis for her non-dissemination order in this case and how it might apply to me. If you read the first paragraph, a lawyer who participates or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. That is not me. It never has been me. It can't be me because I'm not involved in the litigation. She also says
Can I ask you a question about that? Because, I think the case law is quite clear that attorneys who are representing witnesses can be restricted to some degree, partly because they have access to particular information that should not be shared with the public. And if I'm recalling correctly, the state has suggested or has determined that your clients are witnesses potentially. So that's kind of the
and I
issue
address
right
it,
there. Go ahead.
As part of that is that, let's just make it clear, the victim's family has never been involved in this investigation, ever, from the get-go. After Mr. KOHBERGER was indicted, we received no information about anything regarding the prosecution. Nothing. They wouldn't even tell us that a grand jury was being impaneled for Mr. KOHBERGER. They told us that there was a grand jury that was being impaneled, and common sense, we figured it out, because he's the only guy in the county. But they wouldn't even relay that information. They haven't given us any information regarding the investigation of the case. But the most critical part of it is that the prosecution has never, ever interviewed the Goncalves family. So how in the world would we ever be able to be witnesses in this case? And for what purpose would we be? If you're asking about for sentencing purposes, that's post-conviction. That's after he's been convicted on the case. Prior to trial, we're not any witnesses. And that falls into completely different statutes. That falls into the restitution statute. It falls into the victim statute. I just handled that matter in front of the Lori Vallow case, where the judge, I had a motion, the defense did not want the victim's family to appear. And so the judge had to make a determination whether they were immediate family, because it was the grandparents. Completely different statutes because that was post-conviction. And those witnesses were allowed in the courtroom and were involved in the sentencing aspect of it. Okay? So we are in a very, very different factual situation here. I'm not asking as a witness to the case, which witness to the case, they've never ever told us in any way how we would be witnesses in this case, other than the conjecture that we may have potentially. That's not good enough to stop the free speech of the victim's family, as well as myself. Rule only applies to lawyers who are or who have been involved in the investigation or litigation of cases and their associates. If I'm not a party to the case, I can't be involved in the investigation or the litigation of this case in any way. So I would argue that the trial publicity rule of professional conduct does not apply to me as well.
Help me understand what you think you can't say that you've already been saying.
I have no idea. I have no idea what it is.
You've been on the media and you've had interviews, so I'm kind of wondering how do you feel that you've been restrained in any way with this order?
I think you're not seeing what the point is. What the point is that the court has issued a non-dissemination order that restricts First Amendment rights, that is overly broad in almost every aspect of it. Anybody that's interested and they have an attorney, when an attorney who's walking down the street could offer up his opinion in any way, it also takes away from the idea, doesn't the court want victims' families to have representation, to guide them through the legal process? Wouldn't the court encourage that they could explain things, maybe advise them on what to say, what not to say? I mean, if you're taking my voice away, you're taking the voice away of everything. The other part of it is this, is that I'm absolutely blown away that the prosecution doesn't agree with me in this case. The reason being is that they are representing the victims, which in turn are the victims' families. And I have not seen a poorer line of communication in my 22 years of practicing than the prosecution's office and the Goncalves family. And I think it stems from, initially we were critical of the investigation. They wanted to find the person who did this. That's normal emotions. And then from that point on, it has been, we are the enemy. And that's how we feel in this. And so, me guiding them and then trying to limit my voice and helping them out in some way, and then throwing out a random idea that they may be potential witnesses when they never ever interviewed them in any way, it's just an attempt to shut the attorney up and shut the family up, is what it is. Because if I had come to you today and said, we've given 7 interviews, Your Honor, we may be witnesses in this case, we've done all of these things, it may be a different story. We haven't done anything. They haven't interviewed the entire family. So,
well, I don't know what's in all the investigation, obviously, and a lot of us don't know and probably won't know until the trial. Well, let me just say this. I think one of the potential issues is this is potentially a death penalty case. Hasn't been noticed, but that is a potential. and the families of the victims certainly would be witnesses in that process of sentencing. That is not post-conviction technically, is it?
Well, if your goal is fair and impartial jury, right? That's the reason for the non-dissemination order. Well, after the conviction, that goes away.
Well, it's also confidence in the process. So I have that job. I have a job of protecting and preserving the First Amendment and also the Sixth Amendment. And there is some balancing there. That is why lawyers who have access to information that is not accessible by the public have particular restrictions. That's what this whole case is about. In this hearing is about. And would you feel more comfortable if there was a more concrete description of what people could say and what they can't say?
I don't think you have the authority to, Your Honor.
Well, I think I do have the authority.
Well, my argument is that part of the argument is that.
In fact, I know I have the authority to do that.
Well, and the authority would be through your the attempt to have a fair and impartial jury, that you can control people that are involved in the case, correct?
That's part of it.
And we're not involved in the case.
Okay, that's hard to accept. The case law suggests that because you represent potential witnesses, that you have access to information that may not or should not be shared with the public. That's what the case law says.
And I would argue this: what potential witnesses are we? Number one, and what access to information do we have? I think the defense has argued that we have some sort of access because the clients can tell me whatever they want to tell me, right? Well, that's free speech. They can say whatever they want to me, and I can go off and say whatever I want that they said. Because it's free speech. It's the First Amendment. So you can't, this non-dissemination order is so broad, none of the case law applies to people that are outside of the defense or the prosecution. That's the point of it. That's the whole point of a non-dissemination order, because they have access to it. They have access to the information. Victims, attorneys, families do not. And the idea that we may or may not be a potential witness is enough for Your Honor? I just can't see that, especially when there's no history of them ever being a witness.
As attorneys, we have a duty of candor to the court. Mr. Gray has made representations to the court that at best are misleading and in many ways simply untrue. And I need to correct them for the record, because the media is here. I do not want the public to come away with the impression that improprieties have occurred. First, Mr. Gray, on behalf of his clients, has propounded a number of questions to our office and to the investigators. We have answered the ones that we can. We have not shared ones that we are concerned that Mr. Gray or his clients would make public and compromise the integrity of the investigation. For him to say that we've provided no information is simply not true. Secondly, he claims that law enforcement has not interviewed his clients, and that somehow that is the investigator's fault. In fact, from the very beginning, the investigators have attempted to interview his clients, and Mr. Gray has not permitted it. So just for the record, I want to make sure that's clear. Thank you, Your Honor.
In State v. Spencer, the Idaho Supreme Court noted that it is also the duty of the prosecutor to ensure the right to a fair and impartial trial. Under the dictates of Shepard v. Maxwell, the court has a duty to take affirmative steps to address the impacts that intense pretrial publicity can have on a case. As noted in Shepard, Nebraska Press Association versus Stewart, and their progeny, an order like the one in this case is an appropriate measure for addressing that duty of the court. As Mr. Boston's experts have noted, attorneys often have information about a case that may not be appropriate for dissemination in the press. Additionally, attorneys carry a greater weight when dealing appearing on television. For instance, what might be easier for the parties to address is a juror that says, I've seen coverage on the case, but I don't always trust what I've seen on TV, and I can set that aside. What's more difficult is a juror that says, I've seen attorneys for the prosecution, attorneys for the defense, or attorneys for the victims on television talking about a critical aspect of the case. The order in this case is not vague, overbroad, unduly restrictive, or not narrowly drawn. It precludes all extrajudicial statements of the attorneys in this case, attorneys for the witnesses, victims, law enforcement, and investigators. The order addresses, if the court were to apply strict scrutiny, the order addresses a substantial likelihood that pretrial publicity poses to the integrity of the judicial system, and is tailored to ensure that the rights to a fair trial are upheld. Thus, the state contends that the order is an appropriate measure of the court to uphold its duty under Shepherd, Nebraska Press Association, and the like to preserve the right to a fair and impartial trial. At a minimum, Mr. Gray's statements that he's not bound by trial publicity rules or 3.6 in this case illustrate why the order of the court is necessary in this matter. And so we would ask that the court uphold the amended non-dissemination order, or at most tailor it to those statements specifically precluded in Rule of Professional Conduct 3.8.
Would it be helpful to say, okay, you can say these things, but you can't say these things, and be more specific about that?
Your Honor, our initial position is that the total prohibition of extrajudicial statements is the safest and most responsive way in this case to address and preserve the right to a fair and impartial trial.
Right.
Judge, I think a lot has already been said, and obviously we wrote a lot in the briefing, so I guess I'll just touch on a couple of things. In terms of the argument that the victims' families are not involved in the litigation of this case, and therefore don't fall in 3.6, it would be our position that if you have statutory and constitutional rights involved in this case, you're involved in the litigation. Regardless of whether or not the prosecution is willing to work closely with you or whatever issue you have there, the reality is if you have literal rights that permit you certain things that are involved in this case, you're involved in litigation, and therefore you would fall within 3.6 just like everyone else. Second, the standard from Gentile is the substantial likelihood of material prejudice. I don't want to get too much into that, Judge. I think that's kind of this afternoon's argument. I think the main thing before the court, as far as Mr. Gray and the family, is just do they fall within this, and then the court to decide what is appropriate. But I would note that given the vast amount of media coverage in this case, and the fact that it seems like no matter what anybody says or does, in one way, shape, or form, it will be twisted into an attack on my client. We also agree that at this point the safest thing to do is for everyone to just not be talking to the media and allow statements to be made here where we all get a chance to speak and the media gets all that information. If they still choose to do what it is they've been doing, then that's on them. But we don't have somebody who's just trying to whip the media into a frenzy and send this case to the firing squad or probably something like that. So that's our main concern. The only other thing that I wanted to address, and the court addressed this a little bit, the reason we stand silent with grand jury indictments is because there's an old arcane rule that says that if you have a grand jury indictment and you enter a plea, you are accepting the validity of the indictment. I haven't seen a prosecutor try to use that in a long time, but we can avoid any possible claims that somehow we can't challenge anything with the indictment by simply standing silent and having the court enter the plea. So just so that everybody's clear, that's why we do that.
All right, Mr. Gray, it's your motion, so you can respond to what other counsel expressed.
I guess the first thing I would want to address is the prosecution's idea that I haven't allowed our clients to speak with the investigators. You'll realize that the date of the incident, I wasn't retained on this case until close to December 5th, which will be more than 3 weeks after the incident occurred, and they still have made no contact as far as interviewing the victims' families. So somehow that I precluded that in some way is just not true, Your Honor. And as far as scheduling those things, I'll just leave it at that about any of it. So this idea that they are going to be witnesses in this case is just an attempt by the prosecution to shut them up as well as to shut me up. And by the way, people completely forget about this. All of the information that has been disseminated to the public from the get-go was the mayor, Art Betke. Chief Fry had interviews. Bill Thompson had interviews. The coroner had interviews. All of those people had interviews. We didn't. We didn't until we started getting information and started trying to figure out what was going on after they had given interview after interview after interview. That was the purpose of the judge issuing the non-dissemination order, is to quiet them up, not quiet the victims up. They had no control over that investigation from the get-go.
Well, that order was a stipulation between the
That's
state and Mr. KOHBERGER.
That's the other thing, though, is that the court, after that Zoom meeting, Judge Marshall incorrectly said that that was stipulated by all parties. I never stipulated to that. I emailed the
You're not a
judge.
party.
Exactly right. I'm not involved in the
The
case.
stipulation was between the parties.
So,
As you correctly stated who the parties are.
so we would
I
ask.
agree, but you were suggesting that it was entered to shut down the prosecutor's office.
Why would they
That's what you
claim?
just said.
I do think that part of the that was part of the process, is that they understood that their investigation was getting out of hand. Too many people were talking in their investigation, and that's why they stipulated to it. Yes, I do.
Okay, when you say they, you mean the prosecutor's
Yes.
office.
Yes.
All right. Well, I'm not going to issue a decision today. I'm going to issue a written decision. There is a lot of briefing, and I heard some very interesting argument today. And I'll get back to work and try to get a decision out as soon as possible.
So we are going to remain on hold as far as this gag order is concerned. And it looks like Mr. Gray is going to remain unhappy about it, as well as the Goncalves family. Definitely a lot of emotions heard in the courtroom throughout this for this particular argument. And it's particularly interesting to hear the prosecution, slap back when Mr. Gray stated that the state had not wanted to speak with the Goncalves family, and they said, well, that's just not the case. You advised your clients not to speak to us. So I really hope that this can, that their communication can get a little better as far as that's concerned. Because really, in the end, it's all about these victims and getting justice for them. And, and granted, the Goncalves family has been the most vocal, during this whole, after the murders. But, yeah, I just hope that they can, keep themselves in a good way with the state. Because really, that's going to help them, I think. But at the same time, if they do feel like they're being, if they're not being treated, fairly or what have you, it's great that they have their attorney Shanon Gray to back them up on that. So we will definitely see what comes of this, if we get any changes to the gag order in the coming weeks, or if the judge just leaves it be. I mean, at this point, we don't know, and of course, and it looks like we're not looking good for getting cameras in the courtroom either for the actual trial. Doesn't look like the judge is too keen on that idea. So I'm hoping, crossing my fingers and crossing my toes, and crossing your toes is really hard. I'm really hoping that can change, but both the state and defense are pretty against it, and this judge does not seem to be for the media in there either. So we'll hear more about that soon as well. But a lot of things up in the air before this trial even begins. A jury selection process, really. So let me know what you think in the comments. And that's all I've got for this one. Again, I'm going to keep you guys updated as much as I can on the case. And let me know if there's anything else you'd like to be hearing about. And with that said, I hope you have a great rest of the day. And most of all, stay safe.